All right, good evening, all. Welcome to Kirk's Law Corner, Monday Night Law. For those of you that missed me on Friday, I apologize. I took a break. I went camping, dirt bike riding, had a good time. Just my brother and I. It was good. So I hope you didn't miss me too much, but I missed you all. Thought about you, thought about what's going on, but I also wanted to get away from everything, which was kind of nice. I'll have to admit. I'm probably going to go do it again here soon. But we're here tonight to go over some history of law, territory of Idaho. And it's going to be quite telling. Now, I showed this before, we just hadn't gotten all the way through it yet. And I still haven't gotten through all 700 pages of it, but I have discovered some really good stuff and be sharing that with you tonight. Let this get populated here, get some viewers going before we jump into this. There's a lot going on. Again, I keep talking about this stuff, and not everything that we see right on mainstream media, YouTube, whatever, is not reality. You know, Grandpa used to always say, never believe, what is it? Don't believe anything you hear, none of what you hear, and only half of what you see. You know, this stuff that's going on has been going on for quite some time. It's been in the works. We'll call the deep state. Honestly, has been quite. It's been around for a long time. We can go in history and we can go clear back to 400 BC in the making of all of this, of the world human trafficking. (1666) with the Sestakay Trust Act. What is that? In 1666. Now, how many remember about the War of 1688? That's what the English Bill of Rights of 1689 was. Again, this isn't the first time in history. 1215. And I keep finding more evidence of this cycle of a reset. Give us your land, give us your rights, give us your money, we'll take care of you. Over and over and over again in history. It's not the first time, but this might be the last time. Because I think there's some people out there that are a lot more awake today, and maybe even, I don't know, JFK era, How many people remember the executive order from Trump to the heads of the executive departments, releasing the information, the truth behind the assassination of JFK? Okay. They know what's coming. They've been put on notice. I think what's going on today is part of that, trying to stop it, but it's also being used to our advantage. One, to wake the people up to the atrocities that are really going on, and another to hide what's really going on, because many people just could not mentally could not handle this, what's really going on right now. Right? Well, they didn't necessarily delay the info. I mean, they've delayed the info being out to the general public, which is required, but because of the information that's in there about secret societies. Mm-hmm. How many people remember the JFK speech? Now, I've talked with my mom about this and my grandparents about this. They know. They were old enough to know, especially my grandparents. This is what's happening, regardless of what mainstream media says, regardless of what these brand new fact checkers out there can fact check this. Well, I can show you the documentation of it. Now, obviously, I have to be careful here with what I say, right? Because some fact checkers out there might find that in violation of some sort of community standards here. But I just shared here on Facebook a little while earlier ago. I need to go find the actual truth behind it, if it's real true. But it was came through on Twitter that Clarence Thomas, uh, Justice Thomas, basically said that no, social media doesn't have the authority to regulate our free speech. And this goes back to the fundamental principle that it is a privilege to do business in our communities. YouTube, Facebook, Twitter, you're all making money off of your platforms by advertisements and what other kickbacks that you get. You make money. You wouldn't be doing it, right? So we require anybody who's in business in interstate or foreign commerce, right? We require you to be bound by the constitutions. Fundamentally and principally, that's in the Idaho Constitution, Article 11, Section 7 and 8. Section 7 requires you to be bound by the Constitution of the state and the Constitution of the United States of America. Section 8 makes it policy enforcers, the policies, which is the legislature, creates the policy regarding certain businesses, right? Depending on what category you fall in under. That none of your policies can come in conflict with our rights. That's the law. That's the law of the land. And anytime your policies, your community standards, come in conflict with our rights, your policy is to be void for any effect. In fact, your business license can be revoked. So some people out there might be a little worried about Facebook business license, Twitter business license, and your YouTube business licenses. What would we do then? What would we do without YouTube, Facebook, and Twitter? I think we're going to have, right, unconstitutional. So I'm getting some other information out here that somebody else has probably seen it as well. So if anybody happens to have that particular case opinion, if you could just drop it in the chat here, either Facebook or YouTube. Well, I see people on Facebook, but either one of you, if you happen to have that actual case number or citation for that particular opinion ruling found to be unconstitutional, which means things are going to get changed around. Now, I have noticed on Facebook in the last month that Facebook and their censorship and stuff like that has decreased a little bit. I don't know about anybody else, but it just depends on how far out there you are, right? And then what you're posting. The one for Clarence Thomas that gave the ruling. Oh, and Section 230 is found unconstitutional. That's right. That was part of it right there. That was just triggered there. Section 230 was found to be unconstitutional as well. Wasn't Trump talking about that? Yeah, he was. Did we need to get rid of Section 230? And if it is true that this ruling just came out, this opinion just came out and declared that to be unconstitutional, bye-bye Section 230. We're going to probably see a pretty good change here in our Facebook, YouTube, and all that stuff. So, a little update here in Idaho. Of course, our legislature is resuming its legislative session tomorrow. Now, there are some things that, for those of you who are aware of Ammon Bundy and what's going on there, with what happened down at the Idaho Capitol August 25th. Now, there was an usurpation of power by the legislature of the territory of Idaho, or the state of Idaho now, right? I'm going to expose that truth here in just a minute once I get through this view of stuff here. And so they made a rule of procedure that says, oh, well, we're going to create this accreditation. You have to be accredited by them to be the press. Wait, a rule of procedure? But see, this is part of the problem. They say it's a rule. Well, they have the power to make their own rules regarding their proceedings. Yeah, procedure in conducting their business. They've made a rule that says, oh, no, you have to seek permission from us to do any audio, video recording. except for out in the gallery. Well, that's exactly where these people were sitting. And I've found the legislative act behind the Idaho Code. This specifically says that you guys have the power to make your rules of procedure. The actual verbiage from the code, from the act, says rules of procedure. And then it also goes in and it talks about the bar. There's a bar there. And that's where it stops. So there's the general seating area, the galleries. And then on the other side of the bar is your area. You control that side, and we, the people, control this side. In fact, we actually control both sides, honestly. But you've been delegated the power to make rules of procedure and how people can cross the bar, just like in the court, because this is the court of justice. It's how it is done. And the bar is actually just the wooden wall. That's the bar. So in order for people to cross over the bar and speak, where you have the podium for people who want to address the body politic, you control how that happens. But you have no control over the general public seating area and dictate to the people where they can sit, whether they can audio, video record or not. This is the whole fundamental principle behind the liberty of the press. It's the bulwark of liberty so that we can provide oversight and share with our fellow man what's really going on at the Capitol. And this is the right retained by the people. We retain that power. You have no lawful authority at all. And again, we'll go to some case law. What is it? Miranda versus Arizona. There shall be no rule making that would abrogate the rights of the people. We'll all be darned. What kind of rule are we talking about? Shall be no rules of procedure that would abrogate the rights of the people. That's right. So, the legislature in a whole, in adopting that rule or maintaining that rule, because every new elected, so every 2 years they have to adopt, re-adopt, or create their own rules of procedure. They have that power. I get it. But what they don't have the power to do, good. Thanks, Fix It Past. They only have the power to make rules of procedure regarding their proceedings and how they conduct their business. They do not have the authority to dictate to the people how we claim and exercise any of our rights, any of them, zero. They do not have subject matter jurisdiction. And again, this would be one of those times where it's already gone to the judicial branch for a question and answered. It should be self-evident that no, you can't make a rule of procedure. But see, a lot of people don't realize it's actually the full phrase is rules of procedure. Now, there was a certain gentleman that I had a conversation with back and forth there. And I did go back and apologize to him the next day. So I don't want to necessarily blast him, but the fact is nobody really knows that the full phrase is rules of procedure. And I found it right in the Idaho Code. The actual verbiage says rules of procedure. So the Constitution says rules of their proceedings, seedings, okay? But you get down into the legislative act, and that's what it says, rules of procedure. So from the very beginning, the legislature usurped its powers in creating a rule of procedure, granting themselves power to regulate the right to the press. And then took action against people who were exercising those rights and those powers within the area of the general public seating. Just because you put a piece of paper on this side of the bar that says press only, that piece of paper is not law, and that piece of paper is on the wrong side of the bar. Now, on the other side of the bar, yes, you have a little space over there that you've designated for the press. I get that. Credentialed, that's the proper word. Credentialed. Got to be credentialed by them. They have their little committee over there, whatever it does that. You got to submit by a certain date before the legislative session and be approved by them, get credentialed by them to be press. And then they get to determine who the press is. Excuse me? I believe it's Murdoch versus Pennsylvania. You cannot convert a right into a privilege, license it, and attach a fee to it. A license would be seeking permission to do a thing that would otherwise be illegal. It's contract law. It's lawful because that's the law. Article the first is the law. And yes, it most certainly does apply to the states because the states are the one that made it. And then not only that, all of those rights are long antecedent to the formation of the Constitution. So, plain and simple, legislature of the state of the territory of Idaho, state of Idaho, whatever, which I keep saying territory of Idaho because I'm about to blow that out of the water right now. So the fact is they usurped their powers that were delegated to them in creating rules of procedure to conduct their business by creating this, oh, you have to come get credentialed by this little committee people that we created here. And you have to get permission from them to exercise this right in the general public seating. No, I don't think so. And then you took action under that and brought in your friends from the back, to quote Greg Cheney. We're going to have our friends from the back help us out here today. Your friends, Greg, an armed body of men who are clothed with color of authority, says Idaho State Police on it. Guess you didn't read the Constitution close enough, or the Declaration of Independence, where standing armies are not authorized in our form of government. That's what you did. Your friends from the back, you brought in an armed body of men to disrupt and deprive fundamental rights. And then we go to Article 6, Clause 3. Anything in the Constitution or the laws of the state to the contrary or notwithstanding. It means it has no standing in law. In law. So your rules of procedure are in direct violation of Article the 1st of the Bill of Rights. And it's not just the Bill of Rights, it's the right itself. Because fundamentally and principally, we don't even need the Bill of Rights. All of those rights are long antecedent before the formation of government. That's actually the law. Rights as the law. That's the law that government was instituted to secure. Remember? So, this isn't going to play out so well for them because I'm all over it. And so for those of you that are in Idaho that bore witness to that, I mean, I have my own video footage of it. Those that have bared witness to what's going on down there at the Ada County Courthouse, please get a hold of me. I'd love for you to write an affidavit of truth, a statement of facts, and we'll get it notarized under jurat. And then I'm going to do what I need to do with that. I'll take the burden off of the people because they don't know what to do, but I do. What I need is those people to come forward, write the statement of facts, and come see me so I can notarize it. Okay. I've already got a few of the people that were abused down there already. Okay. So that's coming. This is another one of those things I'm working on in Idaho. Trust me, I have a lot of different things going on. And like I've said before, I am working in Idaho on Idaho stuff. And if you're in Idaho, that's great. But please don't send me messages to ask me to help you in another state with some of your own personal cases and that kind of stuff. That's not what I'm here for. I'm here for education. And that's it. What I'm doing here on outside of this education is I'm taking action, right? It's time to lead by example. So, bingo. It's called telling on them. We're going to go tell on them. That's what's going to happen. So when we get enough people together, the victims and the witnesses who put it in writing, and we submit the criminal complaint, that's end game. And I can promise you that. So that's one of the things that I'm working on. So if you're in Idaho and you've bore witness to this, or you're one of the victims of them aggravated battery who put their hands on you, please get a hold of me. Okay. And I'm specifically talking about August 25th. And then again down here at the Ada County Courthouse, when that all went down here, what was that? Crap, what day was that? I should know this, but I don't. I don't remember everything all the time, right? Just some of the time. So with that, I'm going to jump over to some history of law for the territory of Idaho. Ready? So here we go. Get your pens and paper out. Start taking some notes. Now, some of you that watched your a little over a week ago, I went through this just a little bit there. Laws of the Territory of Idaho, the first session, convened on the 7th day of December, 1863, and adjourned on the 4th day of February, 1864, at Lewiston. Also containing the Territorial Organic Act, Declaration of Independence, the Federal Constitution, the Preemption, Naturalization Laws, EDC, EDC, EDC. Okay. Now, Territory of Idaho. I hereby certify that the laws contained in this printed volume are true and literal copies of the enrolled laws passed by the first Legislative Assembly held during the months of December, January, and February 1863 and 4 on file in my office. Now let's take a look at that seal. That is the seal of the Territory of Idaho, not the state of Idaho. What happened to the territory of Idaho? Now, a lot of us are familiar with the Declaration of Independence, right? But right here again, that among these, right, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these, not all, among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men. See, our rights came before government was instituted, and deriving their just powers from the consent of the governed, which means the people already have these rights. The people already have these powers because all political power is inherent in the people. First, the people cannot delegate a power they do not possess themselves first. That's fundamental principle. Okay. To prove this, let these facts be submitted to a candid world. As refuses against the laws of the most wholesome and necessary for the public good. Where is that? He has dissolved representative houses repeatedly for opposing with manly firmness his invasions on the rights of the people. He refused for a long time after such dissolutions to cause others to be elected, whereby the legislative powers incapable of annihilation have returned to the people at large for their exercise, the state remaining, in the meantime, exposed to all the dangers of invasion from without and convulsions within. Internal insurrection. He has created a multitude of new offices and sent hither swarms of officers to harass our people and eat out our substance. He has kept among us in times of peace standing armies without the consent of our legislatures. We require a declaration of war in order to use the military. He has effected to render the military independent of and superior to the civil power. He has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, given his assent to their acts of pretended legislation, for quartering large bodies of armed troops among us, for protecting them by a mock trial from punishment for any murders which they should commit on the inhabitants of these states, for depriving us in many cases of the benefits of trial by jury. How about for abolishing the free system of English laws in the neighboring province, establishing therein an arbitrary government? Oh, well, we're under a state of emergency. That's the arbitrary government. And enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule into these colonies, the same ones that they were getting away from, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our governments, for spending our own legislatures and declaring themselves invested with the power to legislate for us in all cases whatsoever. Can you name one case that's still heard at the common law that's not heard in a court of the United States? Nope. There ain't one. Okay. Those are the key points that I'd like to make there. Fundamentally altering our form of government. Now, we, the people of the United States, in order to form a more perfect union, I want to reiterate that, in order to form a more perfect union, we, the people, establish justice, We the people ensure domestic tranquility. We the people provide for the common defense. We the people promote the general welfare. We the people secure the blessings of liberty to ourselves and our posterity. We the people do ordain and establish this Constitution for the United States of America, not of. All right, here we go. Let's get through that. I want to show this again. The articles. Maybe I should skip that. Oh, we missed. Oh, yeah, this would be the Organic Act for the Territory of Idaho. Organic Act of the Territory of Idaho. But what does this say again? This says amendments to the Constitution. But wait, this says Article 3, Article 4, Article 2, Article 1. Congress shall make no law respecting an establishment of religion or prohibition the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably assemble and to petition the government for redress of grievances. Congress shall make no law. None. Zero. Absolutely none. But again, I want to point this out that these are articles in addition to, which, see, they don't actually show the top portion of the Bill of Rights. This just says amendments to the Constitution of the United States. And it's supposed to be Constitution for the United States of America. Where is for and where is of America? Nonetheless. Now, I'll jump down. Now, this is part of some of the stuff that I covered a little bit. And I've only basically read to about page 178, 700. I was wondering if there was the criminal section, because clearly there's a Civil Practice Act. Wait a minute. This is almost like the law. Uh-oh. Hey, look at that. There's a judgment. But wait a minute. This is the civil practice. All right. Let's jump down to the criminal practice, shall we? This would be a good read too, but I'm going to skip through this. The writ of certiorari and of mandamus. Writ of mandamus, that's a mandate to a lower court. Writ of certiorari. This is still under civil practice. Imagine that. There it is, writ of mandate or mandamus. By what court and in what cases may be issued? See, mandates come from the judicial branch to a lower court. to instruct a lower court for like trial de novo under writ of error, writ of certiorari, writ of mandate. Mandamus is actually the Latin. See, the writ of mandamus may be denominated the writ of mandate. May be issued in any court in this territory except by justice's court. To any inferior tribunal, corporation, board, or person to compel the performance of an act which the law specially enjoins as a duty resulting from an office, trust, or station, or to compel the admission of a party to the use and enjoyment of a right or office to which he is entitled, and from which he is unlawfully precluded by such inferior tribunal, corporation, board, or person. This writ shall be issued in all cases where there is not a plain, speedy, and adequate remedy in the ordinary course of law. It shall be issued upon affidavit on the application of the party beneficially interested. Okay. Just going to briefly cover that because I want to jump to the criminal real quick. Look, contempt. There's contempt of court and their punishments. Huh. I'm telling you, folks, this is a really good read. Look at that. How about more on motions defined? Where to be made, notice of, service of papers, how made, when served by mail, when defendant deemed to have appeared. You know, there's some stuff to know here. How this is all supposed to work. We're still in the civil practice of proceedings in civil cases in justice courts. Courts of justice. But this is going to blow your mind, folks, on this criminal practice. Now, notice this is all civil that I'm looking at right now. Everything that I'm showing here is Civil Practice Act. Now, this would be part of the fundamental law, the organic law, right? Because this is created before the Constitution. This is the first legislative session for the territory of Idaho. Yeah, there's quite a bit to learn and read here. It's all laid out. What we call civil practice. Rules of court, how made, actions against sheriff. What? Sureties, how to justify, actions respecting mining claims, duty of receiver, writs of certiorari by whom issued, sale of property under writ of attachment, certified copies of papers of evidence. The Supreme Court may make rules not inconsistent with the Constitution and laws of the territory for its own government and the government of the district courts, but such rules shall not be enforced until 30 days after their adoption and publication. Come on. Here we go. Now we're getting into the Criminal Practice Act. This is going to be great. Ready to have your minds blown? Now remember, this is the criminal. We were just looking at the civil. Like, would that be like the suits at common law? Uh-huh. Oh, chapter 2. We better go chapter 1. Oh, wait a minute. How could that be? No, that's civil. Okay. Now notice this civil one, right? Approved February 1st, 1864. Now, an act to regulate proceedings in criminal cases in the courts of justice in the territory of Idaho. General definitions and provisions. Crimes defined. Public offenses, how divided, felony, misdemeanor. No punishment except on conviction. Prosecutions by indictment, exceptions. Criminal actions, how prosecuted. Rights of defendants. Second prosecution for same offense. Self-accusation, mode of conviction. Being enacted by the Legislative Assembly of the Territory of Idaho as follows. A crime or public offense is an act or omission forbidden by law and to which is annexed on conviction, first, death, second, imprisonment, third, fine, fourth, removal from office, fifth, disqualification to hold or enjoy any office of honor, trust, or profit under the territory. Whoa, wait. A crime or public offense. Where have we heard that before? In Idaho. Code section, offense description. This is that criminal complaint form A091 on uscourts.gov. I'm showing people how to fill it out. But let's look right here. Still have it up from the last time I showed this. Article 5. The distinctions between actions at law and suits in equity and the forms of all such actions and suits are hereby prohibited. And there shall be in this state but one form of action for the enforcement or protection of private rights or the redress of private wrongs, which shall be denominated a civil action. Gee, I wonder where they got that from. Right there. We're going to go back to it here in just a second, because watch. And every action prosecuted by the people of the state as a party. So the people, as one party, prosecute against a person charged with a public offense. For the punishment of the same shall be termed a criminal action. Public offense? That only applies to public servants, public officials. Uh-oh. So for violations of private rights and private wrongs is civil. And for public servants, it's criminal. Oh, boy. Houston, we have a problem because that's exactly what it says right here. A crime or public offense is an act or omission forbidden by law. Public law. And to which is annexed on conviction a sentence of death or sentence of imprisonment, sentence of fine, removal from office. If you're not a public servant, how in the hell are you going to be removed from office? Think about it. As it is written right here. Section 2. Public offenses are divided into first, felonies, second, misdemeanors. 3. A felony is a public offense punishable with death or by imprisonment in the territorial prison. Section 4. Every public offense is a misdemeanor. Now, Section 5. No person can be punished for a public offense except upon legal conviction in a court having jurisdiction. Well, I'll be darned. Every public offense must be prosecuted by indictment, except first, when proceedings are had for the removal of a civil officer of the territory. Second, offenses arising in the militia when in actual service in time of war, or which this territory may keep with the consent of Congress in time of peace. Third, offenses tried in justice courts. Well, I'll be darned. Section 7. The proceedings by which a party charged with a public offense is accused and brought to trial and punishment shall be known as a criminal action. A criminal action shall be prosecuted in the name of the people of the United States in the territory of Idaho as a party against the party charged with the offense. See that verbiage right there? That's the verbiage that ended up in the Constitution for Idaho in Article 5. The party prosecuted in a criminal action is designated in this act as the defendant. In a criminal action, the defendant is entitled first to a speedy and public trial, second, to be allowed counsel, as in civil actions, or he may appear and defend in person or with counsel. Wait. Appear and defend in person or with counsel. And third, to produce witnesses on his behalf and to be confronted with the witnesses against him in the presence of the court, except that where the charge has been preliminary examined before a committing magistrate and the testimony taken down in writing and subscribed by the witnesses in the presence of the defendant, who has, either in person or by counsel, cross-examined or had an opportunity to cross-examine the witness, or where the testimony of a witness on the part of the people who was unable to give security for his appearance has been taken conditionally in the like manner in the presence of the defendant, who has either in person or by counsel cross-examined or had an opportunity to cross-examine the witness. The deposition of such witness may be read upon its being satisfactorily shown to the court that he is dead or insane or cannot with due diligence be found within the territory. Imagine that. No person shall be subject to a second prosecution for a public offense for which he has once been prosecuted and duly convicted or acquitted. No person shall be compelled in a criminal action to be a witness against himself, nor shall a person charged with a public offense be subjected before conviction to any more restraint than is necessary for his detention to answer the charge. So in other words, they can't incarcerate or require to post bond. No person can be convicted of a public offense tried by indictment unless by the verdict of a jury, accepted and recorded by the court, or upon a plea of guilty, or upon a judgment against him upon a demurrer to the indictment in the case mentioned in the section 292. Something seems a little odd here, right? What is this? Lawful resistance to the commission of a public offense may be made, first, by the party about to be injured, second, by other parties. Now, what are we talking about here? What are they talking about? Lawful, full of law, the right to defend against a public servant may be made first by the party about to be injured, and second, by other parties. Notice that it's not persons. Resistance sufficient to prevent the offense may be made by the party about to be injured, first, to prevent an offense against his person or his family or some member thereof. Second, to prevent an illegal attempt by force to take or injure property in his lawful possession. Now, then it goes into any other person in aid or defense of the person about to be injured may make resistance sufficient to prevent the offense. Public offenses may be prevented by the intervention of the officers of justice, first by requiring surety to keep the peace. Second, by forming a police in cities and towns and requiring their attendance in exposed places. Third, by suppressing riots. Now, again, this is in 1863, December, and 1864, January and February. This is when policy started transforming into police. I showed the etymology on this. I've also showed it in some of the original constitutions. It talks about policy spelt that way. P-O-L-I-C-E is policy. It's 3 syllables. This is fundamentally altering our form of government. Word salad. Turning it into something that it's not meant to be. Whenever the officers of justice are authorized to act in the prevention of public offenses, other persons who by their command act in their aid are justified in so doing. A complaint may be made before any of the magistrates mentioned in section 102 that a person is threatened to commit an offense against the person or property of another. When the complaint is laid before the magistrate, he shall examine on oath the complainant and any witnesses he may produce, and shall take their depositions in writing, and cause them to be subscribed by the parties making them. If it appear from the depositions that there is just reason to fear the commission of the offense threatened by the person so complained of, the magistrate shall issue a warrant directed generally to the sheriff of the county or any constable, marshal, or policeman in the territory, reciting the substance of the complaint and commanding the officer forthwith to arrest the person complained of and bring him before the magistrate. Does not say take them to jail. When the person complained of is brought before the magistrate, if the charge be controverted, the magistrate shall take testimony in relation thereto. Oh, this would be that initial appearance. And we actually have the right to what? Controvert? No, I don't think so. I don't agree with this. Uh-oh. Then the magistrate shall take testimony in relation thereto. The evidence must be reduced to writing and subscribed by the witnesses. If it appear that there is no just reason to fear the commission of the offense alleged to have been threatened, the person complained of shall be discharged. Uh-oh. See, this is supposed to happen at the initial appearance. This is the showdown. Now, if, however, there be just reason to fear the commission of the offense. Now, see, we have to have an accuser here. Do we not? You have to have an accuser and witnesses. You got to have the complainant, and only the man that was injured has that status and standing to claim a right to a cause of action. Now, if, however, there be just reason to fear the commission of offense, the person complained of may be required to enter into a bond in such sum not exceeding $5,000 as the magistrate may direct, with one or more sufficient sureties to keep the peace toward the people of this territory, and particularly toward the complainant. The bond shall be valid and binding for 6 months, and may, upon renewal of the complaint, be extended for a longer period, or a new bond may be required. That's what the bond is for. Is to keep the peace toward the people of the territory, and particularly toward the complainant. So there actually has to be a man, the corpus delicti, the body of the crime, the man. Right here in the organic law, the statutes for the territory of Idaho before the Constitution. Well, here's a problem with that. They can't alter this. Remember, this is the law of creation. And this goes back to the Law of Nations written by Emer D. Vattel, Book 1, Chapter 3, Section 34. Let's see. Do I have that up right now? No, but I can find that real quick. Let's just pull that up. Aha. Here we go. You ready? See, this is the question that's been asked and answered already. And again, this is the law of nations. This is international law that applies to all nations. Just saying. So there's chapter 1. Oops. All right. Here we go. Ready? Of the legislative power and whether it can change the Constitution. Here again, a very important question presents itself. It essentially belongs to the society to make laws both in relation to the manner in which it desires to be governed and to the conduct of the citizens. Remember, citizens are those public servants, public officials. That's also defined in here. That's what a citizen is. Public servant, elected official, or appointed into a position of public trust. Okay. But this is called the legislative power. The nation must entrust the exercise of it to the prince or to an assembly, or to that assembly and a prince jointly. Okay, now remember, when this was written, our form of government wasn't created yet. Our founders read this stuff. Our founders created our form of government based on these 3 books. Now pay attention. So the prince in our form of government is the governor and the legislative assembly. Okay? Who have then a right to make new laws and to repeal old ones. It is asked whether their power extends to the fundamental laws. This is the fundamental laws of the territory of Idaho, because this was laid down before the Constitution was even created. Oh, that's right. Whether they may change the Constitution of the state. The principles we have laid down, principles laid down. See the words that they're using? Lead us to decide with certainty that the authority of these legislators does not extend so far, and that they ought to consider the fundamental laws as sacred, if the nation has not, in very express terms, given them power to change them, which we didn't. For the Constitution of the state ought to possess stability. And since that was first established by the nation, which afterwards entrusted certain persons with legislative power, the fundamental laws are accepted from their commission. It is visible that the society only intended to make provision for having the state constantly furnished with laws suited to particular conjunctures, subject matter jurisdiction. And for that purpose, gave the legislature the power of abrogating the ancient civil and political laws, not the fundamental due process of law laws. That were not fundamental, and of making new ones. But nothing leads us to think that it meant to submit the Constitution itself to their will. In short, it is from the Constitution that those legislators derive their power. How then can they change it without destroying the foundation of their own authority? I mean, think about that. By the fundamental laws of England, the 2 houses of Parliament, in concert with the king, exercise the legislative power. But if the 2 houses should resolve to suppress themselves and to invest the king with full and absolute authority, certainly the nation would not suffer it. And who would dare to assert that they would not have a right to oppose it? But if the Parliament entered into a debate on making so considerable a change, and the whole nation was voluntarily silent upon it, this would be considered an approbation of the act of its representatives. Usurpation of power, treason. Now, again, this is going back to laying down the law, ordaining and establishing it. This is an enactment of the legislature before the Constitution was even created. So what is here, technically speaking, cannot be altered. Period. because this came before the Constitution. All we're acting off of here in 1863, 1864 is the Organic Act of the Territory of Idaho, the law of creation. This is laying down the law of the territory. Period. This is the fundamental law, guys and gals. This cannot be altered. A lot of this that I'm reading right now is due process of law. The process that is due. This is why it's supposed to be fundamental. Like 2 + 2 = 4. It's that fundamental. Now remember, the legislature cannot create bills of attainder, bills of pains and penalties. Which is legislation that prescribes the punishment. If you do this, that's a misdemeanor, and here's the fine or jail time. If you do this, we're saying that's a felony, and you're going to prison and a fine. Now, what are the damages? Who's my accuser? I have the right to face my accuser and the witnesses. Oh, well, we don't have to do that. We can prosecute by information. No, you cannot. No, you cannot. Because that's what it says in here. You cannot prosecute by information except for, in certain instances, like a public servant. That's like these right here. State of Idaho. I want to file a complaint. Public corruption complaint. This is prosecute by information. I'm telling on them. Because that's what they're there for. They're supposed to prosecute on behalf of the people against a person, the public servant, or a corporation like Facebook, YouTube, Twitter. They're supposed to prosecute on behalf of the people because suits have to be in like kind. Wait a minute. Where'd it go? Notice that says United States of America versus the defendant. I, the complainant in this case, state that the following is true to the best of my knowledge and belief. On or about this date, dates of, in the county of, this is the when, this is the where, district of, the defendants violated code, 18 U.S. Code, subsection 241. What's the offense description? Conspiracy against rights. I'll show you guys again. Come on. All right, you. Ha, there we go. You guys are familiar with these guys, right? These are public offense crimes. How about misprision of felony? Look at that. See how easy that was? Here, let's do another one. This could be fun. Let's bump this one down. There you go. Yeah, y'all see that? How easy that was? Right here. See attached statement of facts. Continuing on attached sheet. This criminal complaint is based on these facts. All right. But that's it. Now look at this. Sworn to before me and signed in my presence. Complainant signature, printed name and title. Judge's signature, printed name and title. Date, city, and state. But this is federal. United States District Court for the, and you have to put in your district. See? Has the drop down box for you. All done by states. Come on. Boom. Oh, it didn't do it. What the heck? There you go. Then all you got to do is attach your statement of facts, take it down to the federal district court, your local federal district court, and like it says. Let's see. A complaint may be made before any of the magistrates mentioned in section 102 that a person has threatened to commit an offense against a person or property. When the complaint is laid before the magistrate, he shall examine on oath the complainant and any witnesses he may produce, and shall take their depositions in writing and cause them to be subscribed by the parties making them. So guess what? When you do an affidavit of truth, a statement of facts, and have it notarized by under jurat by a notary public, huh? Yeah. Question: why are the state's districts here? What do you mean? See, these are those districts previously ascertained by law. Our federal district courts, federal courts, territories are broken up into districts. But see what it says here. When the complaint is laid before the magistrate, He shall examine on oath the complainant and any witnesses he may produce, and shall take their depositions in writing and cause them to be subscribed by the parties making them. Sworn to before me and signed in my presence. Complainant signature, printed name. See, we're supposed to lay this complaint before the magistrate. Okay. Yeah, that's because I selected that it's District of Idaho, because that's me. Okay. So, I mean, this online form, you fill this form out online right here, right now. Right? Depends on where you're at. You have to pick your district. See, Georgia's got middle, northern, southern, so you have to know which one you're in. Well, in Idaho, we don't have very many people, so we've only got one federal district court. We're such a tiny population in Idaho, 1.78 million people. But it all depends on where you're at. District of Minnesota. There you go. Massachusetts. Well, they're all in here. Western District of Wisconsin or Eastern District? How about Western? But I mean, these things they're not that difficult to fill out, as we can see. And then where it says print, save as, attach, or reset, you can clear the whole document. You're going to want to print to file, because as soon as you fill these in, you're going to want to print it. And you don't sign this until you are in front of. But what we've found so far now is that they don't want to do it. They don't want to let us go in front of the magistrates. So they say, oh, well, we'll take it. And they do. uscourts.gov. uscourts.gov. 8.5 by 11. That's size of paper. This is how we tell on them, folks, right here. These are military tribunals. All of the federal courts are military tribunals, right? We know that, right? Right there. To constitute tribunals inferior to the Supreme Court. This is Article 1, Section 8, Clause 9. Uh-huh. That's absolutely correct. Now, when you get onto the uscourts.gov, you got to click on the forms, go to criminal complaints, or criminal forms, form A091. I mean, there's nothing really else to this form. You cite the code, and remember, Crime or public offense is an act or omission forbidden by law, not the common law. This is policy, public offense. Public servants are public offenders. This goes back to American Jurisprudence, Volume 16, Constitutional Law, Section 2, that statutes are for government civil conduct. They only have control over that which they create and the powers, subject matter, jurisdiction that was granted to them. Yep. Why do you think 20,000 military personnel were deputized as U.S. Marshals not too long ago? Just for shits and giggles or what? Like I said in the very beginning of this, not everything that we're seeing out there appears the way that it truly is. Okay? Now, what's really going on is, see, this has all been used against the people for so long, we think that's how it's supposed to be. But things have been put back like it's supposed to be, where Trump dug up the executive order from 1984, where they altered it and made amendments to the Uniform Code of Military Justice and the Manual for Courts Martials. How many new justices, magistrates did he nominate and the Senate confirmed? Wasn't it like 183 something? And they still haven't filled all of the seats? Why would he do that? With the instruction to uphold the Declaration of Independence, the Constitution of the United States of America, and the Bill of Rights? From when? 1787, 1791. Why do you think he did the commission, the 1776 commission? How about the Commission on Unalienable Rights? That's right, folks. We're going back to 1776. Make no mistake. We're going back to our original Confederate Republic that our founders created, which can't be altered because it's part of the law of the nation. It's beyond fundamental. But there again, what's a public offense? Only a public servant can commit a public offense, because only a public servant can be removed from office. It can be a disqualification to hold or enjoy any office of honor, trust, or profit under this territory. Uh-oh. Well, that's weird. All right. So, this is the information they don't want us to know. It's pretty simple. It really is. Now, when we're talking about writing the statement of facts, right here, the criminal complaint is based on these facts. Okay. Let's go back over here. The complaint may be made before any of the magistrates mentioned, blah, blah, blah. When the complaint is laid before the magistrate, shall examine on oath the complaint, da, 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 da. If it appear from the deposition there is just reason for fear the commission of the offense threatened by the person or so complained of, the magistrate shall issue a warrant directed generally to the sheriff of the county or any constable, marshal, policeman in the territory reciting the substance of the complaint, commanding the officer forthwith to arrest the person complained of and bring him before the magistrate. This is the way it's supposed to work within the territory of Idaho. But because they have fundamentally altered our form of government and won't even let us file complaints, criminal complaints against them, public servants, we have to go through the federal side because those are military tribunals like they're supposed to be. And they're the ones that are under Admiralty jurisdiction, Article 3, Section 2. Okay? So now let's go look at what a statement of facts looks like. This is the treatise on arrest and false imprisonment. This is the reason why I keep telling people to go get this book and read it. Look, on September 30th, 1992, plaintiff was traveling in his automobile on a public highway called I-35W between, so this is where, when, right? Going northbound when stopped by the defendant acting as a highway patrolman and employee of the state of Minnesota. Short, clear, concise statements of facts. The defendant asked plaintiff to see his driver's license. The plaintiff explained that he is not a licensee under any board or commission and is not required to be a licensee. The defendant insisted that the plaintiff must have the said license. The defendant then arrested, searched, and handcuffed the plaintiff without warrant and over his objections that defendant's acts were in violation of plaintiff's rights and the constitutional provisions of due process of law. Don't say he violated my rights. He violated my rights. Make the statement of fact of what the man did. So, what book? Junior, put the evidence in the car. And that's it. Right there. So the book I'm reading from right here, right now, is the Treatise on Arrest and False Imprisonment. It's on kirkslawcorner.com in the library. You can download it from right there. If you're on Facebook and in the Kirk's Law Corner study group, it's in there. So this is what I've been trying to teach you folks now for a little bit is how to do this, and it's not that hard. It's not that difficult. It really isn't. Okay. And again, what I'm recommending to people out there, because I do get that people are traumatized. I get it. I know, right, Michael? Charles Wiseman, my favorite. I love both the Authority of Law and the Treatise on Arrest and False Imprisonment. Thank you, brother, for sending that one. I cherish that little sucker. I've got it with me. But this is reading means reading, and comprehending means comprehending here. They've dumbed us down so bad that we don't even know how to do this basic stuff of telling on them. I get that people have been traumatized, and that's what part of what they do, right? They want to traumatize us so bad that we're literally mentally paralyzed, that we can't even think. So this is what I'm recommending to people, is to write it out. Write it all out, a story. Then go back through, read the treatise on arrest again, and read those statements of facts and go, oh, okay. And start whittling it down to individual statements of facts one by one. Short, clear, concise statements of facts of who did what. What was the conduct that violated your rights? That's it. That's the statement of fact. What did the man actually do? The conduct. Don't say, well, he violated my rights and he acted under color of authority. No. What was the conduct that he actually did? In short, like Chris used to say, less is more. This is precisely because somebody's got to read this, right? And that this is something I've told people before, is I don't want to hear your story anymore. I've heard thousands of stories over the last 6.5 years now. I get it. I've experienced it myself. Believe me. I have a record, right? I've been branded as a felon. I've been branded as a criminal. Where all of pretty much my whole entire record is driving, and all of it's victimless crimes. So how can it be a crime where there's no victim? Ooh, driving without privileges or driving without insurance. I'm a bad criminal. Possession of something they don't even know what the hell it is. And to threaten me and tell me I better take the plea bargain, or we'll go to trial and he'll make sure that I lose and I get the maximum sentence and spend the maximum time out in the penitentiary if I don't take the plea bargain. Yeah. I know, folks. I know. I've experienced it. I have firsthand knowledge. I've also, in 1985, I was the child that was kidnapped by CPS in the state of Washington. I the child. I know what it's like to be the child, to have the caseworker tell me, oh, well, if your mom loved you, you'd already be back home by now. If your mom wanted you, you'd already be back home by now. That's not something you tell a 14-year-old kid. All right. So, as we can see, a public offense only applies to public servants, because fundamentally and principally, only a public servant can be removed from duty. I mean, unless you're insane here. A crime or public offense is an act or omission forbidden by law, and to which is annexed a on conviction, first, death, second, imprisonment, third, fine, fourth, removal from office, fifth, disqualification to hold or enjoy any office of honor, trust, or profit under this territory. So how can the people in the private be removed from office if we're not? a public servant. I mean, go back to Hale versus Henkel. Go back to Article 5 of the Idaho Constitution. Private rights and private wrongs. Clearly, there is a private side, which is denominated civil. It's a civilized law, civilized process. And suits have to be in like kind. Man versus man versus man in the private versus a person in their proper person as a sheriff, acting as the sheriff in their proper person, acting as the governor in their proper person, acting as a Idaho legislator in their proper person. That's those titles. Now, remember, we're not supposed to have titles of nobility like esquires. Hint, hint, hint. What do you think's coming, guys? Oh, it's coming. Oh, it's coming. Trust me. Believe. Have faith. So, this is the way our form of government's supposed to be working, and what they've done is they reversed it. They've basically scrapped the civilized law, the common law, suits at law, suits at the common law, and have interdicted all commerce onto the people, extended admiralty jurisdiction onto the land in 1845 by congressional act, and they're subjecting us to their pretended acts of legislation. That's not supposed to apply to the people in the private. Do we know the difference between a person and the people in their proper person? Let's take a look at that again. I'll show that analogy or the proof, the facts, the evidence. Isn't that what we got to have, right? Oh, that's First Charter, Virginia. Where's well, I guess we'll have to go back. Huh. They don't have the English Bill of Rights, huh? Here we go. This is what I'm talking about in their proper person, impropria persona. This is a status, a standing. No, another one of these people. No, all crimes are not commercial. No. You're not reading it correctly. Go back and read it. While acting in foreign commerce during the transportation of what jurisdiction are you talking about? Anywho, let's go read here. Because reading means reading. An act declaring, this is laying down the law here. This is how we lay down the law through declarations. Whereas the lower spiritual chamber of commons assembled in Westminster lawfully, fully, and freely representing all the estates of the people of this realm, did upon the 13th day, Lord of 608, majesties, coming call known names. Here we go. Then called and known by the names and style of William and Mary, Prince and Princess of Orange, being present in their proper persons in propria persona. This is a person, prince and princess. That's persons. William and Mary is a man and a man with a womb. That's the names and style. So, what we were just reading there in the commentary or the Law of Nations, a prince in the assembly, a prince. Well, in our form of government, we call that a governor. So, Brad Little, in his proper person, acting as governor. That's what a person is. And those persons are subject to public offenses, and it is denominated criminal. Like I've said before, the common law is civil. You can only get damages. Now, unless you're talking about a capital offense like murder, rape, kidnapping, abortion, and breaches of the peace. That comes from the common law. That's just how it's done. That's how the law is. Okay? So, now, I want to remind people that this all changed during the Trump administration. And this was all made available because of Trump and the many, many, many military members and all of that behind all of the scenes there. This isn't just Trump himself that did this. Okay. There's a lot of people behind all of this. But again, Trump said at his inauguration speech that he was putting the power back into the people's hands. What power is that? All political power is inherent in the people. We have the right to alter, reform, or abolish anything at any time we deem it necessary. Now, if you want to alter, reform, or abolish anything, then you're going to have to learn how that process and how that right works. The right to petition the legislature for the redress of grievances is how we alter, reform, or abolish. Okay? But for right now, I want to try and get people to do criminal complaints. Let's keep it simple, stupid. Kiss. Keep it so simple, it's stupid. It's stupid simple. We got to tell on them. And this is what's been put in place and came effective January 1st, 2020. This is why they've all been crapping their pants. Yep, you're right. But let's read again, because reading means reading. To constitute tribunals inferior to the Supreme Court. Military tribunals. Now, isn't the governor a commander in chief of the military? Yeah, that would be admiralty jurisdiction, wouldn't it? That would be Article 3, Section 2, admiralty and maritime jurisdiction. And aren't they bound by the Constitution pursuant to Article 6, Clause 3? Yep, they sure are. So public servants are under admiralty jurisdiction. And pursuant to Article 4, Section 4, part of what the reason behind creating federalism and splitting the powers is to protect us from invasion and internal insurrection, which is domestic violence, an attempt to overthrow the Constitution and war against the people. So, yes, there is jurisdiction. They're all under military law, admiralty jurisdiction, because they're bound to support it. They're bound by it as a public servant. Now, something I've recently discovered is that the president has the power to remove the governors. And what it says in Article 4, Section 4, we have to comprehend this. The United States shall guarantee to every state in this union a republican form of government, and shall protect each of them against invasion, and on application of the legislature or of the executive, when the legislature cannot be convened, against domestic violence. Now, let's see an explanation there. We're going to find in Luther versus Borden that this has already been discussed. The first clause of this section in somewhat different language was contained in the Virginia Plan, introduced in the convention and was obviously attributed to Madison. Come on. Through the various permeation, good Lord, into its final form, the object of the clause seems clearly to have been more than authorization for the federal government to protect states from foreign invasion or internal insurrection. That's exactly what we instituted the federal government for. 1, to declare war. 2, to regulate foreign commerce with the states, foreign commerce with the Indian tribes. Article 1, Section 8, Clause 3. And to institute inferior tribunals. Those are military tribunals. And the governor of the head of the executive branch is a military term, commander and chief of the Army and the Navy. That is a rank in the military. That's admiralty jurisdiction. So, when we file a criminal complaint against a public servant for a public offense, that is under admiralty jurisdiction in a military tribunal. That's what they're there for. And they're supposed to be there for that, pursuant to our form of government and the Constitution itself. Now, this is exactly what Trump did when he dug up the executive order from 1984 and made amendments to the Uniform Code of Military Justice and the Manual for Courts Martial, which all came effective January 1st, 2020. Now, again, this is exactly why they're freaking out. Because Trump put things back in place like it's supposed to be. And now we're getting equal application of the criminal law. And all we got to do is tell on them. They're there waiting for us to tell on them. It's within our own power to do this. What fine? There is no fine. Did you not read it? Let's read that again. Here's 18 U.S. Code 242. Where's the fine? There isn't one. They've been removed. They're going to prison. Shall be fined under this title or imprisoned for any term of years of life or both, or may be sentenced to death. Where's the fine? There is no fine. It's been removed. They're going to prison or being sentenced to death, guys. Did you read? Whoever under color of any law. Well, what's color of law? What's color of law? Oh, statutes are color of law. Ordinances are color of law. Regulations are color of law. Customs are color of law. It's what it says as it is written. And yes, a lot of the fines have been removed from the United States Code because of what's going on. It does say it shall be fined, but they used to write it in there what the fine was. Now they've redesignated Title 183571, as Huge Chimp says there. But see, the thing is what fine? Like you're asking, who is the fine get paid to? It's $250,000 per individual and $500,000 per corporation, per crime, per violation. That's right. But see, these two, 241 and 242 are the major ones, because if such acts include the use, attempted use, or threatened use of dangerous weapon, that's called aggravated. Explosives or fire shall be fined under this title in prison not more than 10 years or both. If death results from the acts committed in violation of this section of acts included kidnapping or attempt to kidnap, aggravated sexual abuse, or attempted to commit aggravated sexual abuse, or an attempt to kill, shall be fined under this title or imprisoned for any term of years for life or both, or may be sentenced to death. Now, for those out there that don't quite comprehend that you can be sentenced to death for kidnapping, there it is in writing. This works against all public servants. All public servants. This is the public law, public offense that applies to them. We're supposed to be using this against them. They've been using it against us. Yep, sure is. But see, again, they have removed the fines from these crimes because there's no just fining these guys and getting out of jail, paying the fine. No. you're either going to prison or you're going to be executed for treason. So, plain and simple. Now, I noticed the change in this United States code here, I would say about 3 years ago. Yeah. And for those of you that have been following us long enough will remember that I mentioned it on the show. I'm like, whoa, whoa, whoa. What happened to the fines? They took the fines out. Why'd they do that? Probably because, well, you know, if you're ordered to pay a fine and you can pay the debt, you get out of jail. So if you take the fines out, where the sentence is, it said shall be fined under this title, and right there where it says shall be fined under this title used to be the amount fined. Or imprisoned for any term of years of life, 4 years or for life, or both, or maybe sentenced to death. So we remove the option to pay the get out of jail free fine. It's not free, you got to pay. Well, I can commit these crimes as long as I got enough money to pay my way out. So if you remove the fines, you can't pay your way out. Now you got to go to prison or be sentenced to death. Now, military tribunals, death by firing squad, or euthanized is the kinder word, right? Chemical injection. Okay, so, all right, folks. I'm going to leave you with that tonight. What am I doing here? Killing that. That's what I'm killing. There we go. So if you'd like to help, support the channels, help pay the bills, that kind of good stuff, you enjoy this stuff, learning, helping a brother pay the bills. Again, I've lost my PayPal and my Cash App, so the digital side of things are pretty much screwed. But you can still send stuff over to the office at 6477 West Fairview Avenue, Boise, Idaho 83704. And share, right? I want to thank all those that have supported in the past. Thank you for your prayers and your love and your kindness. Another thing is you can get over on the Patreon, patreon.com/Kirk's Law Corner. And again, if anything goes down here, either YouTube or Facebook, you're going to want to go to kirkslawcorner.com to figure out where I went. Especially for those of you that are no longer on Facebook and YouTube goes down. I'll get something on the kirkslawcorner.com to let everybody know where it's going, if there's a new channel, backup channel, anything like that, which I kind of do have something created over there on YouTube. I don't know how that'll work. Yes, actually I did, Amber. Thank you. I got my Trump socks. They're actually sitting on one of the desks at work in my office, one of my desktops there. Thank you. I also finally got that wreath with the picture of Chris in it. Right? And I do want to thank everybody who is over there on Patreon. And again, I'll be on there Wednesday night. Okay. And for those of you that have been on there for a little while, you've already gotten a message about the Zoom meeting ID. Okay. So I have it set up that you don't even need a password. You just download Zoom, install Zoom if you can. If not, you can use the link that's in there, what have you. Okay. So Wednesday night, 4 p.m. Or wait, what time did I start that? 6? So no, I moved it to 5, right? So 4 p.m. Pacific, 5 p.m. Mountain, 6 p.m. Central, 7 p.m. Eastern. Okay. And typically speaking, I'm trying to do 2 hours on Wednesday night. So from 5 to 7 Mountain Time, 4 to 6 Pacific. Okay. 6 to 8 Central, and 7 to 9 Eastern. But some of you know how I can be. I'll just start getting on a roll with things and it can go longer. But I'm trying to limit it to 2 hours, right? I got a lot of things going on in Idaho right now. I'm pretty busy as it is already. So check your messages if you're on Patreon. You already have the information for the Zoom meetings. If for some reason you can't seem to make it, let me know, right? Especially if you're in tier 3 and tier 4. We'll work something out. Now, the tier 4 peeps, I'm trying to get with you guys on a one-on-one. So be looking for my messages to you that are in the tier 4. We can start getting those one-on-ones going. Okay. Oh, right on. Okay. Thanks, Rob. Right on, brother. See, there's another gentleman out there who's like scouring books. He's bringing me some American Jurisprudence second edition volumes, 62, 62A, 62B, 63, 63A. Right on. Thank you, brother. Appreciate it. There's been a couple people that have donated some books, and I'm greatly appreciative of. Reading means reading, and it is what it is, right? So, when I'm referring to PayPal and Cash App, because I mentioned a certain something, about the thing, and it was in controversy to their things, and well, you can't do that. You can't say something that might be contrary to what they say. Well, you're all public servants. Excuse me. I think I'm the master here. Coupled with the right to freedom of speech, hell, I have the right to say something that's totally contrary to what public servants seem to think is the truth. That's the whole point behind the right to freedom of speech, to speak freely. Yeah, I miss Chris too. In fact, I had a strange dream early this morning about Chris and all of this being like he's still alive and kicking. It's crazy. But yeah. So again, want to thank everybody who's here wanting to learn, and all of my supporters. Greatly appreciate you and your prayers, your love, and your kindness. Thanks for sharing. Subscriptions over here on YouTube and the thumbs up on YouTube. I know some people are having a hard time sharing. I don't know why. I when I go look at it, it's available to share. Even when I log in on my other YouTube profile, I can go in on to Kirk's Law Corner and share. So I'm not sure what's going on with. I mean, could be getting censored yourself. So um, yeah. So yeah. Someone send me a PM that I never go on and tell me what the thing Kirk is talking about exactly. The thing, the elephant in the room. We all know the thing. There's that one thing, and then there's that other thing too. So that's still in the works. And then there's this other bigger thing that's coming too. So that one's in the works too. And then I've got this other little thing that I'm working on. So uh, yeah, there's a few things going on, those things. So that's actually what I was thinking. Either Rumble or BitChute are basically my two top choices, top, you know, top idea choices. Um, so, like I said, if anything goes down, I'll go on kirkslawcorner.com. I need to figure out how I can just go live from kirkslawcorner.com. I haven't quite learned enough about how to do the server stuff, all this fancy extra stuff. But one of these days I might get there. We'll see. Might have to do it out of necessity, but who knows? Who knows if this might get fixed here shortly, especially with, if Section 230's been found to be unconstitutional, this is going to get tore down, right? Facebook and YouTube are going to have a hard time using their community standards against us because Section 230 has just been found unconstitutional. That strips them of that fact checking power and, oh, well, our policy says that's in violation of our community standards. You can't do that. So, yeah. Oh, boy. Well, anywho, much love, everybody. Thank you all for being here. And we'll see the Patreons on Wednesday night. And anybody who's new that signs up, I will send you a private message. So make sure you check your Patreon messages Wednesday night. Okay. So again, much love, everybody. Have a good night. We'll see you Wednesday, if not Wednesday night on Patreon, then Friday night fun night. Good night, everybody.